Good evening. My name is Steve Garner. I am president of the Missouri Association of Trial Attorneys this year. I practice law in Springfield, Missouri. I've done that now for about 28 years. I've represented businesses, I've represented hospitals, I've represented doctors, and I've represented injured people through the years, and I've represented insurance companies. We heard earlier when Mr. Beckerman, who I know well and have a lot of respect for, say there have been case law that has come down to 2 to bad eggs. Insurance companies that wrongfully denied coverage. And what this bill does is it entices insurance companies to deny coverage. It hurts small business who's paid for that coverage, and when they're denied, can't afford a lawyer, and they don't want to accept the lawyer provided by the insurance company. It hurts individuals who are denied coverage or only get coverage under reservation of rights, meaning at the end of it, you may have to pay it because they're not going to. It hurts doctors, it hurts municipalities. If you look at the list of cases where insurance was wrongfully denied, Butters versus City of Independence, one of the cases was a wrongful denial of coverage involving a small hospital, Lakeside Hospital Association. Every individual in the state is subject to having a claim filed against them. Even if coverage is absolutely clear, coverage can be denied, and then that individual has to be defended by a lawyer, not of his choosing, but by the insurance company's choosing. You know, the quote, "No man can serve 2 masters," is true. You've got lawyers, and I know a lot of defense lawyers, have a lot of good friends that are defense lawyers. They hate defending under reservation of rights. And why is that? Because here this insurance company is saying, the insurance company that pays them like for all of their business, is saying, we don't think this guy's a permissive user. And if he is a permissive user, then they got to pay. So it comes time to do your depositions, or it comes time to take sworn testimony. And you've got these people here wanting to deny coverage where they don't have to pay anything. And then here's your poor insured who's sitting there, whose life is in their hands, and instead of trying to show facts that show coverage, that lawyer has a very, very difficult, if not impossible, choice to make. And that's why the courts of this state have said, when you deny coverage, when you ask to defend under reservation of rights, it is the consumer, it is the business, it's the doctor, it's the farmer, it's the logger, it's the construction worker who has the right to say, I don't want a defense under reservation of rights. Here are the facts. You've got the most critical party to the equation of whether there's coverage. You're insured. Any issue you want to know, your insured can tell you. And they've got an obligation under the policy to give you a statement under oath. The man that bought the policy, the woman, the doctor, whoever it is, can provide you virtually every fact that deals with coverage. And you can make that determination. And that's why the courts say, guys, if you defend under reservation of rights, it's the policy holder who can either accept it or reject it, because he's the one that's paid the premium. Now, if you're right and there's no coverage, there's no penalty whatsoever. If you're wrong, I think these people said it's a tiny number of cases that this even involves. If you're wrong, then your insured has the right to protect himself. That's the way the law is. It's not unfair in cases where an insurance company feels that there is no coverage. They have a right to file what's called a declaratory judgment action. It's a separate action where they can have a court determine in an expedited fashion whether there is or isn't coverage. And while this case is going on, they can depose those same witnesses, they can require appearance of people with records, and they can prove to the court that there's not coverage. So they have a way to protect themselves. The first way, of course, is talk to your insured and be certain of your denial. And the second way is to file a declaratory judgment action. The other thing that is this bill covers that's beyond a defense under reservation of rights. If you read the provision, it says the insurance company can reserve rights but the insured is obligated under all provisions of the policy. So we can tell you we may not pay this judgment, and we're going to provide a lawyer that works for us, but you have to follow every provision of this contract. So we're hedging our bets, but you can't do that. Currently, the law says if you want to hedge your bets, then the insured has the right to protect themselves in a means that they feel to be appropriate. And what I've seen, you know, these gentlemen were talking about things that they've seen. I've seen people that brain damaged a young man walking down the side of the road, clearly coverage. There was a denial of coverage, and before the denial of coverage, they did an asset check on their insured, and it was in the claims file. He has nothing to lose. I've heard and had cases where there's been a complete denial of coverage, and when I deposed the insurance adjuster who was responsible or executive, he knew that there was a case in Missouri right on point allowing coverage for that person. It is a tiny group of cases, but it will be a larger group of cases if this legislation is filed, because the insurance company now can defend under reservation of rights for as long as it goes on and then deny coverage. At that point in time, the insured, where is he? He's left holding a potentially very large judgment that could have been settled earlier had they accepted coverage. The bill simply hurts a lot of people for what they say is a tiny number of cases. And I would submit to you that it's just not fair.
Are there any questions? Representative Colonna.
I was to inquire.
Go right ahead.
Mr. Garner, you actually reminded me of the resolution to my story, and that was, yeah, I used to do workers' comp defense, but I stopped doing workers' comp defense the day that, you know, for you non-lawyers, you know, you get a file, you evaluate it, you know, here's what it's worth, here's what we can do to kind of mitigate the damages, and let's be real. Having walked in those shoes, you try and mitigate the damages that you're insured or that the company is liable for. You just do it within the confines of ethics and the law. I had a case where I presented the value, here's how it's going to play, and the adjuster goes, yeah, deny the claim. Well, but why should we deny the claim? Nah, just deny the claim. But if we deny the claim, they're going to go get one of those evil plaintiff lawyers, and they might do this, that, and the other. That's going to cost you more money. Apparently, you didn't understand me. Deny the claim, and that's the last defense case I had. But anyway, let me make sure I understood your testimony. You're rephrasing what you said. If we change the statute, again, you have the insured, you have the insurance company. If we change the statute, what you're really doing is putting that insurance company defense lawyer in a huge dilemma, an ethical dilemma. Because on the one hand, yeah, they got to defend that third party because their insurance coverage may or may not cover them. But on the other hand, you also are facing that dilemma of, let me extract some facts that can show that at the end of the day, when we're done with this trial, the insurance company doesn't pay a dime. Is that the dilemma that you're talking about, that this legislation brings to the forefront?
That's exactly it, because if you're really representing the individual, you should be trying to prove coverage. And if you're proving coverage, you're probably not going to get another file from that insurance company.
Yeah, and I understood that too in those old days. You also said something that perhaps you can distinguish for me. On that question of declaratory judgment, I thought the other gentleman told me, no, we can't do that, and you just said, yes, we can do that. Dave, I don't understand. How can one person say we can and one person say we can't? Did I misunderstand somebody's testimony? Or?
Maybe. I mean, there's no question that an insurance company can file an independent declaratory judgment action. What they cannot do is, if they tell you I'm defending under reservation of rights and they reject that, the insured says, no, I want your full commitment to me, then they cannot intervene in the case. In other words, the law says you can't have your cake and eat it too. You can't say we're going to defend you under reservation of rights. However, when you reject that, we're still going to be allowed to come into your case and do whatever we want to prove that there's no coverage at that point.
Last year's bill. Okay, I get that. All right, so just to make sure that I understand exactly what's going on. Lawsuit A is the question, the injury suit. Is there coverage or not coverage? I don't know. The insurance company, if they want, can file lawsuit B for a declaratory judgment to determine whether or not there's coverage over here, correct?
No question.
So they can do that now.
That's correct. Under this bill, they would enter the actual claim and I guess try to prove no coverage against the insured in the actual injury claim.
Which, again, in that scenario, you've got that, and I'm not picking on insurance defense lawyers, but that lawyer is placed in another ethical dilemma from the standpoint of who do I represent? Do I represent the insured, or do I represent the insurance company, correct?
The insurance company certainly is put in that dilemma in that case.
Wow, this is great. Present status, that second lawsuit, that declaratory judgment lawsuit. In your experience, I'm anticipating people saying, oh, that takes too long and we don't know what's going on. Has it been your experience that those are put on expedited dockets? I mean, it's just a question of law, not necessarily a fact. How does that play out?
No, I mean, I can't give you an exact time frame, but you can move for summary judgment pretty rapidly in a declaratory judgment action. And a lot of times, if the matter in dispute is significant, they'll be brought in federal court, and that's for a large part of summary judgment practice, in my opinion. I mean, that's just how it looks.
So they actually, and again, I'm unfamiliar, so they don't necessarily go to another state court in that jurisdiction, they go to the federal court, I guess, because of the different contractual issues that are involved, or?
They don't have to stay in state court. I've had cases where they filed in federal court.
Wow, okay.
We try to remand, sometimes we can, sometimes we've not been able to.
Thank you.
Any other questions for this witness? I've got one, I guess. I want to get clarification on what I'm hearing, and I'm just going to ask you, but I'm starting to get a little confused. So we have a situation where we have a non-permissive driver, or a question mark about whether or not the driver is permissive.
Yes, sir.
Okay. And we have an insurance company, and we have the policy holder, the person who actually paid the bill, in this case, small business owner, the small business owner, not the driver of the vehicle, but
yes,
the small business owner. Okay, who has the determination right now to where they can say, no, insurance company, you have to leave or stay? Is it the driver of the vehicle, or is it the business owner or policy holder?
Generally, it's the business owner that would be sued that would have that right to say. They actually both could. Oftentimes, the driver's going to be sued and the business, and then the insurance would cover the driver, and it would also cover the business. So they both technically have the right to decline a reservation of rights, but certainly the business that is also the ultimate recipient of the judgment would have the right.
So in a case where the driver refused, but the policyholder wanted them to stay in, they would be able to stay in?
They would be able to stay in, exactly, yes.
Okay. What about conversely? Let's say the driver wanted them to stay in, but the policyholder didn't. Then what would happen?
Then they could stay in for the driver.
Okay, I was kind of confused about that, because we really got three parties here, not two.
And oftentimes, in that situation where you've got multiple parties under one policy, sometimes they'll have one counsel for both. But usually that's more in a situation where agency is admitted. But, you know, that's a perfect example of the insurance company having both the company and the individual driver that they have access to, and the company can either say they were not a permissive user. It's not a difficult, that analysis and that example is not a, in my opinion, in practice, a difficult question to answer very quickly.
We've heard now we're using a company as an example, but as an individual, you know, we've heard earlier that individuals are hard to track down to get them to say, and sometimes, and there again, just for disclosure, I'm an insurance agent as well.
I didn't know.
So I can see where there's a conflict. Let's say Grandma doesn't let Junior drive the car, but Junior goes out and gets in an accident. Now Grandma's got a conflict of interest to where she's going to tell the truth, he wouldn't be covered, or is she going to say, oh yeah, I let him drive it? So you're putting Grandma in a position there, you know what I'm saying?
Right.
So you have the third party involved again, once again.
She's the insured, and if grandma says he has permission, grandma's
Right.
testimony is probably gonna remain he has
Right.
permission.
All right, well, that's kind of getting off track. Okay, thank you. Any other questions for this witness? Seeing none? Okay, thank you. Make sure you fill out a form.
Thank you all.
Anyone else here testify?